Good afternoon, everyone. My name is Francesca Guerrero. I'm a partner in Thompson Hine's International Trade Practice. I would like to welcome you to today's webinar. First, I'm delighted to introduce our panelists. We have Jerry Fang, who is a partner in Zhong. His practice focuses on dispute resolution and regulatory investigations. He has a law degree from both China and the United States. Before attending law school at Columbia, he was a civil law judge in China. Then he practiced at certain US law firms before joining Zhong as a partner in Shanghai. Also joining our panel is Michelle Lee, who is an associate in the International Trade Practice at Thompson Hine. She also is qualified to practice law in both China and in the District of Columbia. She has a JD from Georgetown and is a resident in Washington, D.C. Today, our presentation, actually, let me give you the CLE information, a few housekeeping items. The program is being recorded, and we will send a link to all of the attendees within 48 hours of today's presentation. We will be offering CLE credit for today's webinar, so please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel on the right hand of your screen. The form provides instructions as to where to send the completed form, and I will announce the tracking code, the CLE code, at the end of the program. In the handout panel, you can also download a copy of the PowerPoint slides as well as bios of today's speakers. Again, thank you for your interest, and we'll get started. Today's presentation, I'm very excited about this topic because it's new, it's extremely important, and it's extremely confusing. So we're hoping to shed what light on it we can. We're going to be discussing not only China's new export control law, but some of the additional statutes that have been passed in the last 6 months in China that all relate to export controls, and we want to understand how they fit together in sort of a big picture way. So without further ado, I'm going to first turn the presentation over to Michelle Lee, who will sort of give us some background on the US-China business relationship, some recent actions, very briefly, that the US has taken from a trade perspective with respect to China. And then we'll turn over the core of our presentation to Jerry to talk to us in detail about these new statutes in China. Thank you. Michelle, you're on mute.
Sorry, everyone. Thank you, Francesca. Good afternoon, everyone. US and China economic relationship has grown more and more interdependent. Data and statistics show that this relationship remains robust last year, despite the trade war between the two countries. In 2019, US exports to China totaled an estimated $163 billion US. In the same year, US imports from China totaled an estimated $471.8 billion US. US investment in China in 2019 alone is $116.2 billion US, with Chinese investment in United States in 2019 being $37.7 billion US. We also see many developments in US trade and investment regulations targeting China in recent 2 years. A lot of these developments are driven by US economic and security concerns. Section 301 report in 2018 includes concerns that China requires or pressures US companies to transfer their technology to Chinese entities, places substantial restrictions on US companies' ability to license their technology on market terms, directs or unfairly facilitates acquisition of US companies and assets by domestic firms to obtain cutting-edge technologies, conducts and supports unauthorized cyber intrusions into US companies' networks to access sensitive information and trade secrets, and highlights China's Made in China 2025 plans. The report states that China targets to pursue global preeminence in certain high technology industries, setting explicit market share and other targets to be filled by Chinese producers, both domestically and globally. The Special 301 report dated April 29, 2020 continues to report on IP appropriation concerns, highlighting 38 online markets and 34 physical markets, which include China, that are reported to engage in or facilitate substantial trademark counterfeiting and copyright piracy. Privacy and data security are another major concern of the US government. As Chinese companies like TikTok gain access to US markets and ever more data on American citizens, many have argued that federal privacy legislation has become a national security imperative. One aspect of the conundrum is many worry that data privacy and national security are increasingly interconnected. Data and data networks can be exploited in ways that threaten security, but they also form the lifeblood of technological innovation on which both economic growth and national security depend. Recent actions include the Section 301 tariffs on certain goods imported from China, which many conceive to be overly expensive, as it covers $200 billion of imported Chinese products by List 3 alone, and List 4 tariffs on May 2019 cover another $300 billion of Chinese imports, even though List 4B never went into effect. As a result, more than 2/3 of the consumer goods the United States imports from China now face higher tariffs. Recently, we have assisted many importers to file a Me Too lawsuit at the US Court of International Trade, challenging the validity of these tariffs. And for certain importers, we have also added additional causes of actions challenging the USTR's tariff exclusion denial decisions as applicable. DOJ also issues a report illustrating its enforcement focus in trade secret theft. In response to trade secret theft, DOJ forms a CCIPS section within the criminal division consisting of a specialized team of 45 attorneys devoted to enforcing laws related to computer and IP crimes, and establishes a CHIP program, CHIP program, which is a network of federal prosecutors who aggressively pursue computer crime and IP offenses. On April 2020, Commerce BIS issued 2 new final rules tightening military end user/end use rules, which leads to an increase of the compliance cost of many US companies that do business with China. The new rule is one of several recent export control actions taken by BIS, including the elimination of certain license exceptions to prevent what Commerce sees as circumvention efforts by China and Russia and Venezuela to acquire US technology under civilian use pretenses. We have assisted many clients in analyzing the impact of these new rules on their business. July 1st, 2020, the US Department of State, Treasury, Commerce, and Homeland Security issued a business advisory to businesses about the risk of supply chain links to entities that engage in human rights abuses, including forced labor, which could include withhold release orders, WROs issued by customs to prohibit importation of products of suspected goods benefited from forced labor, civil or criminal investigations, and export controls. On the company sanctions side, recent actions include extensive use of the entity list. The placement of entity list prohibits the export of US origin items such as goods, software, and technology, and other items subject to the EAR without a license to these entities. This includes re-export. To many, the first time they have heard of the US entity list may be in March 2016, when ZTE Corporation was listed. That 2016 listing had to do with allegations of evasion of US sanctions against North Korea and Iran. More recent entity list designations have derived not only from US economic sanctions, but also tied to various other types of US allegations or policy concerns. The United States has made frequent use of the entity list to target Chinese companies over various national security concerns, Since 2019, BIS added Huawei Technologies and 114 of its overseas-related affiliates to the entity list. Companies wishing to export US items were required to obtain a license. In May 2020, BIS amended its long-standing foreign-produced direct product rule and the entity list to narrowly and strategically target Huawei's acquisition of semiconductors that are the direct product of certain US software and technology. We have assisted many companies to evaluate the impact of the listing on their transactions. On the same day of the Xinjiang Supply Chain Advisory was out, US Department for Treasury's Office of Foreign Assets Control (OFAC) sanctioned one Chinese government entity and two current or former government officers in connection with alleged serious human rights abuses in Xinjiang region. As a result of this action, all property and interest in property of these entities that are in the United States or in the possession or control of US persons must be blocked and reported to OFAC. Further, unless authorities are authorized by a general or specific license, US persons are generally prohibited from dealing with any entities placed on the SDN list. EO 13959 prohibits investment in public traded securities issued by the designated Chinese military entities, derivatives, and similar instruments. Next, I hand this presentation to Jerry on the China Export Control Law.
Thank you very much, Michelle.
Thank you very much. I'm speaking from my office in Shanghai, and it has been a great privilege to speak with Francesca, Michelle, and discuss with the new export control law. Michelle, can you go to the next page? So the new export control law, Michelle, can you move the slides to the next page? Yeah, first of all, before I start, I want to make some disclaimer. So the new export control law is newly enacted, and a lot of the the concept and mechanisms stipulated in the law are still unclear and still pending for the implementation rules. Some of the my discussion and the reading are only of my own, and it does not represent the positions of my law firm, and it does not represent the position of the Chinese government, of course. And I'm a lawyer duly qualified in the US and China, and I'm not a party member, and I don't speak for the party or for the government. First of all, let's go to the slides. So the export control law was adopted on October 17 of this year, and it has already become effective. It immediately caught a lot of attention, and practitioners like Francesca have been discussing with me many times on the new law. First of all, I want to point out that even though the law is the first codified export control law, but before that, we already had a existing control list and other various existing regulations. For instance, as early as 1997, China has already had a control list on the nuclear products, and after China's WTO joining WTO, China also published other control lists on dual-use chemicals, biological products, as well as other control lists. So the export control law is the first consolidated and comprehensive regulatory framework. It's of course capture the existing control list, but it has a lot of new features that we will be discussing in the later slides. Two major driving factors for the new export control law domestically in China. China has seen itself catching up on a lot of high technology industry. It wants to codify the export control regime on the international front, enforcement activities, by the U.S. government, as Michelle has just pointed out, also prompt China to pass new laws on China's own version of export control law.
Sherry, as you move to the next slide, I would just like to direct people to how to ask questions. I didn't mention that earlier. We will be preserving time at the end for questions, but if you have any in the meantime, please type them into the question box on the right-hand side. And if it works that we can clarify them during the presentation, we'll address them as we go. So please feel free to type in your questions now.
Sure, yeah. Yeah, we can go to the next slide. So these slides, talks about the comparison between the PRC and the US. I'm not a US law expert, so I only talk about the ECL under the new ECL in China. So the new ECL regulating both the items, the items on the control list, as well as the end users. What we put here is as the subjects. So the end user that exports, importer and exports and end users, they are also being regulated, under the China ECL. Go to the next slides. Okay, key control measures and methods, as we just mentioned, the export control list, after in connection with the new ECL, China has also consolidated the dual use item list, as well as the military military items. Those lists are also you will also see in the later slides that we have put in the slides. So the measures and methods includes export control list, which basically consolidated the existing list. The new features, under the PRC ECL is also the law provided, temporary controls of goods, technology, and services not included in the export control lists. It also adopts a licensing system for the export of controlled items, and it established a control list, that relates to the subjects, which means importers and end users. The first three methods, are for the item controls, while the last methods are for the subject controls. Control items under the PRC ECL, the control item is defined, in the ECL as slide 12, please. Slide 12. Sorry. Yeah. So the dual use, the scope of control items includes dual use items, military products, nuclear and other goods, technology and services, as well as other items that relates to the safeguarding of the national security and interest and performance of international obligations, such as non-proliferation. So although ECL reference dual use items, the list of control item appear to be more limited than the US lists. Francesca, you have seen the list. So what is your comparison between the practice in the US and in China?
I would say that although the lists are more broad than the US munitions list, which covers only defense items in the US, it is still more narrow than the commerce control list. It does seem to focus, at least the current list, on items that are connected to weapons, terrorist activities, missiles. So they use dual use, which kind of has is almost a term of art in the United States. But I think, you know, U.S. export control practitioners should kind of recognize that it will be a little bit more narrow. Also, there appears to be no concept similar to the country chart or the reason for control, which is something that's important under the EAR, where, you know, you might have an item that's controlled, but only if it's being exported to, you know, a dozen countries. Here, the items that are listed require a license regardless of which country it's being sent to.
Yes.
So
Yeah.
yeah.
Yes,
And
I
also,
agree.
I'll note we'll talk about the import and export of technology later, but those
Mhm.
lists, I think, which is a completely different statute, are more broad and will seem more like the commerce control list to U.S. practitioners, I think.
Right. So we will discuss, in addition to the ECLs, you know, China also has regulations on the import and export of technologies. They are very much, you know, related to the ECL, but it's still a separate, you know, regime, which we will discuss later. And also, I want to point out that just one issue. Most of the items, you know, the controlled items on the list does not have designated country destinations. However, there was a few, you know, a few chemical products that potentially can be used for drugs. They have the specific country designations under the China consolidated lists. Michelle, we can go to the Francesca.
And we have one question. Is the controlled list aligned with the Wassenaar agreement? My understanding is that it's not, but I just would, you know, I mean, China is not a signatory to that, correct?
Sorry, can you say that again?
The Wassenaar agreement, that the
Mhm.
U.S. is a party to, and many European countries, Australia, et cetera.
Right.
We had a question from a participant as to whether the controlled items list is linked to that. And my understanding is no, but I just wanted to.
No, I don't think so. Yeah, it's not linked to that list. Okay, we can go to the next slide. Yeah, so here, you know, we list the two, you know, existing control list items. You will see that there are basically two major, you know, control item lists. One is dual use items and technologies, and the other is the military items. You know, before 2019, the consolidated list has its own separate list. So, you know, as a control list, the Chinese government is trying to consolidate, you know, the list, and it also consolidated the regulations into the new ECL. And those lists are, you know, publicly available on the MOFCOM websites. If you are interested, you can take a look. Michelle, we can go to the next slide. Yeah, temporary control is something new. It does not, you know, is a new feature under the ECL. The temporal control give the Chinese authority to impose temporary control over certain goods, even if they are not on the consolidated control list, and they can make an announcement, you know, for the temporary control. The duration of the temporary control should not exceed 2 years. So this is something. However, you know, because the ECL is just became effective, we have not seen the temporary control has been, you know, put into use in the past.
Barry, we have a few questions coming in, but one is specific to temporary controls. Do you have an example of when a temporary control would be enforced? I know this is a new law and we may not have them yet, but is there any sort of context you could provide for when this might be used?
Yeah, so it's I think these provides, you know, additional flexibility to the authorities if they feel that the certain products, even though it has not been captured on the consolidated list, which normally will be updated annually, and to the extent certain items are not captured in the existing control list, it's possible the authority may impose temporary control and based on their discretion. And in addition to the temporary control, there are also supplementary control that we can talk about in the next slides.
Great. And I don't want to slow us down because we have a lot to cover, but do you know if there's a website where people can track items subject to temporary control?
No, it has not been put in use yet. So once the implementing regulations of ECL is published, then we'll see how these temporary control can be implemented. For now, okay, we don't have any temporary control.
And one last question I will touch on briefly. Someone asked if the consolidated list will be modified based on the new export control law. I know the answer to that, Jerry, because we've already been talking about encryption control modifications, right, and that'll be part of the presentation later. So the answer is yes, it will be modified, and we'll talk about some that have already happened.
Yeah, normally, even before the ECL, the control list has been updated, every year. So we think that, that once, the MOFCOM and other authority will continue to update the consolidated list, on a yearly basis, and it's possible they could, be more frequent, updates. There might be more frequent updates on the list as well. So as we were talking about the temporary control. Here, the law also provided a supplementary control, which will be used, when there are under certain circumstances where, for instance, certain goods, technology, and services may be used for for terrorist purposes, or maybe used in a way to endanger national security and interests. Similar to a temporary control. Supplementary control under the ECL has never been put in use. However, when we discuss with the practitioner in China, people are thinking that certain goods, if the government feel that could be used for terrorist purposes, and of course, these might get fairly critical. But for instance, if to the extent if the government feel that a certain products, regular product can be used for protest or for terrorist, or street movements, the government may also, use supplementary control to stop exports of certain products to certain region, for instance, like in Hong Kong, when there are certain special times. So that could be possible. But like I mentioned, those temporary control and the supplementary control are still pending the implementation regulations. Michelle, next slide. Yeah, we talk about the regulating mechanism to regulate the items. Here we also want to talk about mechanism to regulate the subjects, meaning importers and exports, as well as end users. So the law does provide that for the first time, that the end users, provide mechanism for end user control list. The company can be put on the control list if they breach the requirements for administrations of end user or ultimate usage, or the companies are being likely to endanger national security and interests, and using the control items for national for terrorist purposes. For the importer and the end users on the control list, the PRC authority may prohibit or restrict transactions of relevant control items with the importer and end users on the control list. There's the exporters and end users on the control list, they can apply for an exception, once they are being put on the control list. And the regulations are on how to get it removed from the end user list are still being published. Here in these slides, we talk about the export license requests. First of all, for a Chinese, exporter to export certain controlled items, it will first have to obtain the export business qualification. It's a separate from, from the license to the export license. It's the basic qualifications for the exporters. For any exporter in China that will deal with the controlled items, the exporter have to apply with MOFCOM, and there's a website for them to register and apply for such exporter business qualifications. In addition to the export business qualifications, the exporters will also have to apply the export license from MOFCOM. And each the export license will be applying to different control items, and each different control items will have different application materials, and the MOFCOM also provided on its website how to apply for export licenses for control items. In general, when the exporter apply for such a license, it should provide a copy of the contract and user certifications and the description of end users. Those will all be required for apply such license. We can go to next slides. Yeah, like we the ECL also provided that the exporters should submit to the MOFCOM a document certifying who are the end users and what is the ultimate usage of the control items issued by the end users or by government agencies in the country or region where the end user is located. It's not been, we have not seen, this been widely used. However, what has already been widely used in China is when Chinese importers are importing from certain countries, the MOFCOM can issue end user certifications based on the request of the end users, and provide it to the exports in other country. That has, those practice has been fairly common already in practice. The ECL is the reverse end user certification. It will be the end user certification from importer in other countries. It will be provided to the Chinese exports, which will be submitted together to the authority in China. And similarly, such end user and ultimate usage certifications can be issued by the end user or by the government agencies in that region. And I discussed with certain clients, whether one of the questions is whether when importers in another country, when they imported certain control items from Chinese exports, whether they will be able to resell after a few years. The question, the answer will be no, because the end user of the control items well, they should undertake not to change the ultimate usage of the relevant control items or transfer such item to any third party without the consent of the Chinese authority. I think this mechanism is very similar to the U.S. export control, measures, right, Francesca?
I'd say it's similar to U.S. export control measures for defense items. So again, I think this is where there's more similarity to the ITAR, the way it operates, than the EAR. Some items under the EAR obviously face similar restrictions, but consistently items under the ITAR do. I would also like to throw in a question that we have. One of our attendees asked, is there specific language for the end user declaration? Is there a form that people need to sign, or is it more flexible depending on circumstances?
Yes, the end user forms they have been there are templates of those forms, and the languages is usually we use standard languages, but those are still is I think it could change it could change pending the implementation rules. We can go to the next slide. Okay, so the general export license under the ECL, Article 14 of ECL provided that where an export has established an internal compliance system for export control, and the export is in good operation, the authority may grant a general license or provide other facilitation measures for relevant control items export by the export. The export control, I want to mention that given China already had existing control lists, the general export license for the previously existing control list also exists. But it was not, it was all based on the regulations, and it was not comprehensive. So the new ECL, we believe that the more comprehensive, more consolidated general export license will soon be provided and in the implementation rules. So it is expected that such a general license, similar to what we had already, will allow transactions of certain type of transaction to occur over a period of time, rather than requiring a transaction by transaction license. For instance, one of the existing export license, that is currently being used, it could provide the export a license that they can not one license for one batch. In some license it will provide one license for 12 batches, and of course each batch needs to be reported to the authorities. But it's not it's to a certain extent it will, I think that the authority will also want to streamline the process, does not want to have the require the exporters to get every license for every batch and every transactions. We can go to the next slide. Yeah, the law, the new law has provided or increased the potential penalties. In addition, to the warnings and orders to to the subjects, mostly Chinese exporters. It will also it also provides other penalties, including confiscations of illegal gains, and fines, monetary fines up to 10 to 20 times of illegal overturns. These is I think is one of the major changes, because under the existing, all the old regulations, the fine is, the fine amount is much lower, and mostly based on the illegal income or illegal profits. Here, the new ECL, provided fines which is based on illegal overturn or revenue. So it will be the violator will be penalized with a much higher fine amount. In addition, as we discussed, the exporter will have to apply before apply the export license. They will have to get qualifications. So in here, the exporter may also be suspended or disqualified for their business operation or business qualifications to export. It could also be denial of certain export privileges, for instance, AEOs, and their shipments will be subject to strict inspections. In addition to the administrative penalties, under the Chinese law, which normally means fines and other administrative measures, there are potentially also criminal liabilities for violating the ECLs. And of course, the Chinese criminal law prescribes various laws, including smugglings, and alterations of government official or government documents, as well as potentially illegal business operations. So in addition, the violation of export control law may result in various punishable crimes under the PRC criminal law. Also as a feature under the Chinese PRC Penal Code, in addition to the legal person, to the company being penalized, in China, what we call there's a concept under the Chinese criminal law is called directly responsible supervisors and other responsible persons may also be criminally liable and penalized. Those supervised and persons refers to the management, the legal representative, and other high level or even lower level staff of the company that were directly involved in committing such crimes. So, and yeah, and the penalties for individuals may include imprisonments, as well as criminal fines and other measures. Okay, next slide. Yeah. So as many practitioners are waiting for the implementing rules, there are certain areas, certain issues under the ECL still awaiting regulations and the rules. For instance, whether and the definition and scope of service being subject to the control, and general license, as we just mentioned, whether will be the standards and procedures for obtaining such a general license, and the detailed process of determination and specific standards for the control list on importers and users. Those, and also the ECL also mentioned about the exports, the re-exports and the deemed exports. One worrying feature for a lot of multinationals is that the shipments from country A to China's bonded areas, and then reshipped to country B, may also be considered as re-exports under the ECL, even though from customer and the tariff perspective, it was never within the China's cross China's customers, but it could still be regarded as re-exports. Those rules are all within the implementing rules and regulations. The market expects that also when in a recent international conference, a high-level official of MOFCOM commented that they have been working on the implementing rules, and they should be published fairly shortly. I think normally based on our prior experience, maybe within 3 to 6 months we will see the implementing rules, and we can have a discussion at that point. Michelle?
Jerry, I know we want to make sure we keep on time, but I'll just interject quickly on a question. Someone asked if there is a list yet available where you can search for companies on the control list. That is not available yet, correct?
Yeah, that's not an available list, and the end user control list has not been published yet, and also the determination of the end user are not therefore are not yet available yet. And I think eventually such end user list will become something that you are familiar, the entity list in the US, and parties, especially the exporters, will be able to search and find out who will be on the end user list. Before we wrap up on the ECL, I want to cite the positions from the MOFCOM, and also as the market views both the ECL and the end user control list will not likely be very extensive, and China still does not want, at least I think it's my personal view that Chinese government does not want the ECL to become a block for international commerce, or for the R&D centers to be established in China. We will, in the latest slide, we also talk about the unreliable entity list, and it has been announced for almost a year, but so far none of any foreign companies has been designated as unreliable entities. So let's talk about the commercial encryption. Commercial encryption is there recently, as Michelle earlier mentioned, recently the MOFCOM, as well as the state cryptography agency and the customer, they jointly published an import and export and procedure rules on applying for license for the commercial encryptions. These commercial encryption, the import and export list are related to ECL as well. However, it's because encryption, China has its own encryption law, so it's also relates to the encryption laws, but I think it's relevant to be included here. Similar with the export license, import and export license, there are also procedures, and also the procedures of obtaining the import and export license for commercial encryption. We will also shed some lights on obtaining the license for other control items under the ECLs. for instance, whether what kind of materials will need to be submitted, and what is the reviewing process and the legal implications. Another point I want to make here is for the commercial encryptions, you will have 3 agencies, to jointly review the import and export licenses. For other controlled items, the MOFCOM may also work together with other agencies, for other type of controlled items. Michelle. Okay, as we mentioned, the consolidated export control list seem to be fairly narrow. It only covers the military items, the dual-use items, and dual-use items, normally refers to the nuclear, the biological products, chemicals, certain chemicals. It seemed to be fairly narrow compared to the U.S. list. However, China has a separate regime, which is the export control of certain technology, and this is the we are what we are talking about is the export control of technology. Is not it's relevant to the export control of controlled items, but it's more focused on the technology side. As you can see, there are certain levels of regulations and administrative measures, as well as a catalog, and the catalog, itself it has also been updated in August this year. Next slide.
Jerry, I will just interject a comment here so that people understand that the technology controls only apply to exports, like you said, of technology. So the items on this list, it's not going to apply to the sale of widgets or the export of software. It's only like the transfer of the technology.
Yes, it's only for the sharing and the transfer of the technology. However, I want to clarify, the controlled items under the ECL covers both the goods as well as the related technology. However, the control items under the ECL is fairly narrow. It only covers the military and dual-use items. While here, for technologies, it could apply to, AIs, super computing equipments, as well as other algorithms and certain, area of 5G technologies. Those will be subject to the export control of technologies.
We got a question. I'll just answer it. Does the technology control list differ from the ECL? Yes, it differs significantly from the ECL. It's a different list completely.
Yeah, it's different, and it covers fairly different, areas of technologies. Okay, we can go to next slide. Okay, as we just discussed about the, what will be regulated under the technology exports. So it's not just the transfer. It's also, it talks about the transfer of technology from PRC to overseas through trade, investment, or economic and technology cooperations, such as patent assignments, transfer of patent application rights, patent licensing, transfer of tech secrets, and technical services, as well as other forms of technology transfer. And of course, you know, the difficulty of the Chinese law is oftentimes, you know, the definition are not clear enough and could be interpreted as fairly broad and ambiguous. And we have received questions from clients and multinational corporations. For instance, whether one of the concerns is that to the extent certain technology is under control, and whether it will be permissible under the regulations for a non-PRC employees or engineers working on the projects that relates to technology subject to export control. There have never been such enforcement, and we think if the companies continue to to follow the earlier practice and without intention to trying to hide anything or do something unusual, we do not think the new ECL, of course, doesn't really cover the technology, only covers the controlled items, or the broad applications of technology export regulation will not cause any immediate necessity of any immediate changes of practice. I think in general the intention of the Chinese government, they do not want to do not want to scare multinational corporations from doing business in China. Michelle, we can go to the next slide.
Sherry?
Yeah.
Just to interrupt for a second, we're going to keep going. I know this is a topic of interest to a lot of people, and lots of people want to follow this. But if you have to drop off after an hour, the CLE code is Export Law 2020. That's Export Law 2020. You can get the form on the side. And again, we're going to go ahead and run over the time so we can cover all of our content. But there you go.
Yeah. So, so there are three categories of technology exports. One category is, is free exports. But even for free exports of technology, you would still have to register the contract with the authority, and it normally takes 60 days. And for restricted exports of technology, then you will need to go through the licensing process, and without obtaining the license, the exports cannot be completed. And of course, there are certain type of technology which are subject to prohibition and cannot be exported from China. Next slide. Here is an application, as a very interesting application or examples of how technology export regulation might kick in. Michelle already talked about mentioned TikTok, being very popular in the U.S. and overseas markets, and there are TikTok and its parent company, ByteDance, has run into such a scenario. Starting August 2020 of this year, ByteDance has been forced by certain U.S. Executive orders to explore various options, including a sale of TikTok operations to international or to the U.S. buyers. This has, of course, captured a lot of attention in China, and TikTok, and of course also made judicial challenges in the U.S. courts. However, in China, you know, on August 28, 2020, the MOFCOM issued an updated version of the catalog. In the earlier slides, we talk about the regulations, administrative measures, as well as the catalog, which will be updated, once every few years. The update of the catalog came in the midways after TikTok or database ByteDance is working with the U.S. buyers for a potential sale or potential joint venture. So the updated version of catalog kicks in at a fairly sensitive times, and right after the updated version of the catalog, the Chinese official news agencies commented that the company should consider whether to suspend its negotiation and fulfill its legal legal obligation to file procedure before making any actions. And shortly after that, the ByteDance announced that it has reached the agreement in principle with U.S. companies, and announced that it has submitted an application for permit of technology or export with the Chinese authorities. So these are the recent cases where the technology exports kicks in and become a fairly important issue of an important transactions. We talk about the unreliable entity list. Unreliable entity list is it was initially proposed last year, and in September this year, the formal list or the formal regulations titled as provisions on the unreliable entity list is issued by the MOFCOM. Under the provisions, multinational companies, may be put on the unreliable entity list if they are found to have endangered the sovereignty, security, and the development interests of China, or they are being found to have interrupted the normal transaction with the Chinese enterprises, or taking discriminatory measures against the Chinese enterprises, and which will seriously harm the legitimate rights and interests of the Chinese enterprises, organizations, and individuals. So the UEL is fairly new, and even though the provisions, and also the provision also provided, certain measures, in the last slides we talk about which companies could potentially be put on the UEL list, and once the company put on the UEL list, there will be certain negative measures against those entities on the list.
Jerry, I just have a couple of requests for the CLE code again from people who have to leave. So it's Export Law 2020. That's Export Law 2020, all one word. Thank you.
Yeah. Okay. So the UEL list is it's of course separate from ECL, but it also has certain relevance to the ECL. For instance, companies listed on the UEL will be restricted or prohibited from engaging imports and exports with Chinese counterparties. But the UCL has other negative measures as well. It could restrict and prohibit foreign entities investment into China in China or other convenience or licensings, work permits, or qualifications. It could also impose a fine corresponding to the seriousness of the case against the foreign entities included on the UEL list. And of course, the provisions also provided certain procedures for entities to petition for removal from the UEL list. So far, even though the UEL list has been discussed for a while and the provisions has been published in September, so far none of any multinational corporations have been put on the UEL list. And I think the market consensus is that the Chinese government will likely be very cautious to put on the multiple multinational companies on the UEL list, because the general policy is China still wants to, investments from foreign countries, and in the recent 1 or 2 years, China has further opened its domestic market, and certain industry, including financial industry, has been further opened to foreign investors.
Jerry, are
yeah.
there any entities at all on the UEL list? I know you said there are no multinationals, but have there been any other persons placed on the list?
No, so far, no one and no entities has been put on the UEL list. However, in the political areas, we have seen a lot of, going a lot of, activities or noises. Actually, besides from UEL, it gets to fairly political, sensitive topics. Certain companies, including Boeing Defense, have been sanctioned by Chinese Ministry of Foreign Affairs, but those are separate from UEL, and it's more, relates to political, and other, and the sales of weapons to Taiwan, for instance, they were sanctioned by the Ministry of Foreign Affairs, or PRC, and that is separate from UEL. But I think the UEL, may also considering, the sanction list of Ministry of Foreign Affairs, and may also taking consideration of end users, control list under the UEL. Okay, so that's I think that's all about UEL, and we can move to the next slides. So
Great. Jerry,
yeah.
before we get into some of the more complex business considerations and discuss this, there are several questions. I will say I've gotten more questions out of this webinar than any other webinar I've done, so that shows me that there's a tremendous need for more information, and people are watching this closely. One of the questions relates to, on the export control list, they're often referenced, the references include the HTS code as opposed to an ECCN or something that Wassenaar Agreement countries are used to referencing on the commerce control list, and sort of how companies can reconcile this difference. And I have a couple comments, and Michelle, who's taken a look at the list, if you want to rejoin us, Michelle might chime in. My impression is that the list does not list things by HTS code. It may reference it, but then the description itself will be more narrow. So it's a little bit more like looking at the munitions list. You need to look at the description pretty closely. There's no code that may fully capture, or cross-reference it. And I think, frankly, that multinational companies are going to have to start maintaining two lists, at least. They're going to have to, have their products classified under more than one list. And if there's anything else you'd like to add to that, please jump in.
Yeah, yes. Definitely, from the MOFCOM and the PRC customer perspective, they will look at, what items are being exported, based on the HS codes, and certain products will immediately be captured, if they fall into, if those HC codes are related to the controlled items, and of course, when you apply the license, you will the export will also needs to describe, the the technical specifications of the items and then in its usage. And if you look at the consolidated list, it's not as extensive or specific with regards to the functionalities of control items, but it does describe, why certain items, is subject to control. For instance, certain chemical, they were subject to export because they can be used for manufacturing drugs, and especially, for those goes to certain countries, and the exports will have to apply a special license for exporting to certain countries, including to Afghanistan.
Okay, and then another question was, is there a concept similar to the de minimis concept under U.S. law? And I know we've discussed this, Jerry. A product that is exported from China and incorporated into another product, through further manufacture, is there going to be some sort of de minimis concept where that further manufactured item might be captured under the Chinese export control law, as well as whatever the law is in the manufacturing country?
Sure, there's no such concept under the ECL for de minimis rules. But as we discussed earlier, the consolidated list is relatively limited. However, if you talk about the export of technology from China, then I think we will have to determine whether those technologies are PRC technology or overseas technologies. And I think we can argue that if those technologies are not PRC technology, then it will not be subject to the regulations for export of technology. So similar arguments, such under the de minimis rules then can be made, for export.
Okay, thank you. And there was a question about the general license, which we all know we'd love to have, but they don't have rules about it yet. How broad do you think the general licenses will be once they implement rules? Do you think that they will allow an exporter to export to any end user in any country, or do you think they will be issued on a more narrow basis, like to this one end user in this country, as many transactions as you want within the scope of 2 years? Where do you think that will head?
I personally think that it will likely, be instead of per country, general license, we'll likely adopt, both country list as well as end user list. Since there will be control list for the importer and the end users, and a general license, will likely be limited with who you can sell to.
Okay. And then let's see. There's another general question sort of about whether you expect these new laws to curtail exports from China.
I don't think so. I think you know the China still wants to do business with the rest of the world, and it's fairly critical for China to maintain economic development, and it is actually the major reason to maintain the legitimacy of the government. So I don't think the government will wants to hurt the trade and investment, and that is why we have not seen or we have not seen, or at least publicly reported cases where multinational corporations has been caught up in the export control cases.
Okay. If we'd like to talk about some of the business considerations.
Yeah, I want to also point out, as I mentioned that there are existing, general license, and under the existing general license, there are two type of license. The type A, general license permit export operator to export to certain region or country, and Class B general license permits specific users in certain country or regions. So maybe the general license will have both type of more broader general license as well as a narrowly designed general license.
Okay. So you're saying much like when they produced the export control law, they consolidated existing lists, there are some existing general licenses that any exporter can make use of, and they give us some guidance on what future general licenses may look like.
Right.
Okay, and so that's interesting and something we haven't discussed too much, Jerry. Do you expect the general licenses under the export control law to be broad, like something that any exporter can use, or do you think that exporters will be applying for a general license that only they can use?
Yeah, exporter will likely apply for general license for they can use, and they will likely needs to submit it for end users, and so I don't think that the other exports who have not applied the license will be given the convenience of a general license by the other export.
I thank you.
Yeah, and I do want to chime in here because the ECL makes it clear when it comes to general license provision, it has a condition saying that you have to be fairly a good citizen, maintaining a great due diligence compliance system. So it sounds like it's going to be an exporter specific general license, mechanism going forward, especially under that provision.
Okay, yeah, we can wrap up, talking about the certain business considerations, whether, the technology we're facing during control regimes, whether, R&D centers, will be influenced by the export controls. I think, like I mentioned many times, I don't think that the Chinese government intended that locations of R&D centers will be influenced. However, I know multinational corporations do have concerns. Before we know more, we have more clarity on the ECL and implementing rules. I think as of now, the NMCs does not need to change, immediately of what they have been doing. However, it's important to monitor, the recent developments, and what the changes, the changes of the market practice, and we multinational corporation can start to consider get more infos, get more familiarized with the ECLs, and be ready, if they need to make any changes. And on the unreliable entity list, there was some concerns, among the practitioners, whether compliance with U.S. export restrictions, whether it will cause company to be placed on China's unreliable entity list. Many corporations were worried, including non-U.S. companies. For instance, certain Japanese companies, subject to the U.S. export control, they will have to terminate transaction with, for instance, with Huawei, and then their immediate concern is whether such termination of business, transaction will lead them to placement on China's unreliable entity list. Of course, there are theoretical risk, if they are regarded as not honoring the commercial contracts. However, I think the risk is fairly low for two reasons. First, for U.S. company and the non-U.S. company that do business with Chinese company like Huawei, they normally will have provisions under their contract. They can terminate or suspend under force majeure provisions and or export control implications. So I do not think that compliance with U.S. export restrictions will put them into a difficult position of not complying with the contracts, and more importantly, I don't think the Chinese government want to massively use the unreliable entity list, and yeah, and so far yeah.
I just wanted to underscore what you said, Jerry, which, if you don't already have that in your commercial contracts, you should have a provision like that, because that will help you have a good justification if you are in a position where you need to cancel a contract. So,
right.
Yeah.
And also, I also want to point it out, one kind of like one type of activities that might be viewed as not honoring commercial contracts. Certain companies, for various reasons, maybe reputational reasons, they want to, even though their products and services are not subject to U.S. export restrictions, but nevertheless wants to terminate contract with the Chinese counterparties, and those type of activities might be captured, might be determined as a bad faith, bad faith acts, and maybe I think the risk of getting placed on the unreliable entity list could be higher. And of course, I think Francesca, you had a very good point. I think when the company needs to first of all needs to have certain provisions in the contract, and then secondly also needs to show the good faith, that it is trying to perform the contract, and even if they want to terminate the contract based on the U.S. export control restrictions, it's better that they have opinions from the councils, or they have applied, for instance, Qualcomm and Intel's, they have they applied with the U.S. BIS for continue to do business with Huawei, and those efforts are considered as good faith, and I do not think even if they cannot ship certain chips to Huawei, they will risk being put on the UEL unreliable entity list. So third point on the slides, the employees may face new restrictions on working on sensitive technologies in China, and this is still is only potential risk, and we do not think there are immediate risk for your employees to continue to working on the existing projects.
And Jerry, I'd like to repeat something that the more I talk to you, the more I try to remember this point. The deemed export concept, which is where you really get into foreign nationals, working in China or maybe in other locations on Chinese controlled technologies. Deemed exports only seems to really be a concept under the export control list, which again is a more narrow list of items, very kind of defense, missile, biological weapons focused. And it doesn't appear to be a concept right now on the export of technology list. So the items that are on that catalog of technologies, you know,
Francesca, I cannot hear you. You were cut off for 5 to 10 seconds. Yeah, but what you were saying, I think is accurate. The deemed exports, relates to the export, the control items, which is relatively low, and it doesn't, immediately kicks in the technology exports. So that's why I host the view that we need to change the practice for now, and we do need to monitor the developments carefully. Yeah, and last point, as Francesca was mentioning, the multinational corporation probably will need to have two sets of list, one for Western list and one Chinese list. I do think that previously I think multinational corporations are more focusing on the compliance for US and European control lists or sanction lists, but given China is adopting the ECLs, the unreliable entity list, as well as updating the catalog of technology export, there's also certain needs to start start to put in more resources for compliance for your Chinese subsidiaries regards to the new Chinese laws.
So I would like to thank everyone for sticking with us, and this is a really, really great topic, and I can see that most of the attendees have stuck around. If we didn't get to your question, we're going to have to follow up with you by email, because they are literally going to kick us off of the webinar platform in 1 minute. We've reached the end of our time. But Jerry, thank you very much for joining us. I think this was great, very educational. Michelle, thank you for the overview of what's been happening from the US side, so we keep remembering that it just all works together. And again, we'll follow up with you by email if we didn't answer your question. And one last time on the CLE, it's Export Law 2020. Thank you very much, everyone.
Thank you, everyone. Thank you.
Thank you, everyone.